Mr. Fergerstrom filed document number 96. In response, Mr. Kanaile joined at document 122, or moved to join, and Mr. DeLeon moved to join at document number 123.
Hello, Harry Fergerstrom. I'd like to start with my first motion. I tried to do what you were talking about, separate them so they're clear. The first motion is to reconsider all motions, applications, or requests for admission or intervention as a party or other parties in this matter. And this is based on the rules that state that there is a certain timing in which parties can be entered. It also says that you have to be present the day of the hearing and that you have to follow up within 10 days with your essentially a motion to enjoin. There is no place in the law that says 4 years after the fact that you can suddenly open it up for new people to come in. I understand what you're thinking. However, it puts us, I'm including myself in this because, quite frankly, the whole thing is so convoluted. You know, when the Supreme Court says that the permit is vacated, then there's no permit to contest. That's what I keep on saying, and I believe Mr. Werdeman said the same thing, and I support him on that. You're putting the horse before the cart again, and I'm at a severe disadvantage because before you let me in, and I brought this up several times in the July 17th hearing. I think I brought it up 6 times, and I was told that I was not a party yet, so I couldn't say these things, and I understand that. Same thing with Ms. Keoy, I cannot make a motion unless I'm a party. And so we have a certain disadvantage. There's 1,000 pages lodged that has already been granted, and that if I'm a full party, then I should have a right to say something about those motions. And so this is just what I'm trying to say to you is that we need to follow the law. And the law is very specific on who comes in and what time. And so the entry of all the parties that intervene now is not timely. It is not within a time structure. The proper procedure would be, because the Supreme Court vacated the permit, would be that they reapply for that permit. And I would like to mention that David Ige, your governor, has said it 3 different times in 3 different places that the university is in the process of reapplying for the permit, which is not what we're seeing here. What we're seeing here is jumping in the middle of an ongoing case, and suddenly we are new parties, and all that other stuff is already lodged, and we have really nothing to say about it. And even when I try to say something about it, you commented several times that I was not a party, and so I don't have a right to do that. And so, and I just like I want to say many things about many of these things, but quite frankly, if we follow the rules, all of this is going to be null and void anyway, because the rule says so. There's a process that has to be followed. I'm calling you on the process, you know, and I'm saying I gave you exact reasons why. It is right out of Title 13, Chapter 5, on how the contested case is supposed to be heard, how the parties are to be entered, and quite frankly, this is so convoluted that you're just not following any of this stuff. It's almost like you're thumbing your nose at the Supreme Court. This is the cart before the horse, and I keep trying to bring this to your attention. I tried to bring it before July 17th. I sent you an email. You did not answer me. That email also went to Michael Kane, and the response I got was there's no ex parte communications. I'm just trying to get some clarification, because the clarification on the process is really, really important, because quite frankly, this is all out of the process. And I don't see how you could possibly deny what I'm saying on all 3 of my motions, quite frankly, because they all are, the second motion is a motion to strike, and there's also a motion to replace all of you folks, because you folks are very well familiar with Title 13, Chapter 5, and you played party to this charade, because it sure seems like a charade, to this whole thing, and quite frankly, I have no confidence in any of you guys anymore, because you participated in something that you knew did not follow the rules. And so I'm sure that you don't appreciate it. I'm sure I'm not the most appreciated guy ever, but that's beside the point. This is part of the process. It's outlined in Chapter 13. Title 13, Chapter 5. It's right out of the books. I even have a copy that you folks sent me. Not that I couldn't get it. I wanted to make sure it was from your office or from the office of the DLNR. So I'm saying it specifically because this is what it says. So I'm not making up anything here. I'm not coming up with some kind of suggestion that is not part of what is the process. I would like to be able to engage, but when we're on an equal playing field, this is not an equal playing field. There's no fairness in here. There's no transparency here. I mentioned this over and over again. If I am truly a party, then I have a right to challenge any motion that's been done. You keep washing it over like there's only one person that can challenge. You know, I mean, you don't ask if anybody else wants to challenge Pueo or anything else like that. You don't ask those questions, which I think is really, really pertinent to this, if I'm a party. And I have opposition to all this. I have so much opposition to it that I think that you need to reset this thing so everybody's back on the right playing field and we're even. Because right now we can't even identify who half of these parties are that are mentioning to us. There's documents coming from all over the place. I have no idea who these people are. They're not identifying themselves as somebody who's supposed to be this. They're partners to another company. We don't know these things. And this is why it's so important that the transcripts be available for at least viewing for all the parties, because we are at a certain disadvantage. You've also disadvantaged me. You had mentioned the library. That's an extraordinary inconvenience for me. I don't have access to that library. I haven't had since I was about 16 years old. I guess I had an outstanding book that never was returned. I don't know, but somehow or another, I'm not allowed to be in that library. And so I have mentioned this before. I don't have the capabilities to do just electronic information. I try, and once in a while I can catch it. Most of the time it's blocked. I don't know how they are able to do that. I'm telling you that it's something that I brought up on July 17th. I told you that to not have this problem, where we're going to argue about whether I got something or not, send me a copy. Don't tell me it's on some electronic piece of paper that I don't have access to. I mean, I believe the law says you give me a copy. And I had requested that. The only party that has paid attention to that is Mr. Sinkin from the Temple of Lono. And so, again, I'm at a very, very much disadvantage. I can only right now base it on the rules of the contested case. And the Supreme Court said that the permit cannot stand. We therefore vacate the judgment. That means it's null and void. Being the third court of Judge Nakamura and the permit issued by the board. That says it's not there to complain about. The proper procedure, so we can get all these things out on the table correctly, is to reapply, have a public notice, have a public hearing where all the parties, all those in this room can go ahead and testify all they like and bring all of those matters to light, but on an equal playing field. Not where I come in where you got a 1,000-page slide and tell me that I can't even say anything. That's not a full party. You are denying me that right to due process. And I brought this to your attention before. It's been ignored, but believe me, I'm going to keep pressing that because this is the law. I didn't write it. It's out of HAR. Title 13, Chapter 5. It's very clear what it says here, how people come in as a party, when they come in as a party. There is no provision in this Title 13 that allows an intervention 4 or 5 years after the fact. I don't know how you would argue with me or tell me that I'm wrong, because it comes right out of the paper. It comes right off the ruling from the Supreme Court. If you're going to deny my motions, I would certainly like to have findings of fact and conclusions of law and logical reasoning how you can circumvent the rule of the Supreme Court. Because that's what's happening here. Yes, but I think we're going to discuss that a little bit later, which is about subpoenas. I need to know how to do that in order to get my part on the books. A lot of it has to do with the watersheds, and that's very much in my ballpark. I've been practicing on Mauna Kea forever. I'm well known by Office of Mauna Kea Management, University of Hawaii. I've been in these contested cases before. The only thing that stopped me last time, I went to jail for a traffic ticket. Other than that, I would have been a party for all these things. So, again, my motions, I have 3 motions in front of you. A motion to reconsider, a motion to strike, and also a motion to remove hearing officer, attorney general, and the director of conservation lands, because they all played party to this convoluted idea that you can usurp the instructions of the Supreme Court. By making all this, I mean, you allowed this whole thing to proceed like this was not incorrect. And so I don't have any trust in you or the Attorney General's office or the Owner's office to give me a fair shake. Quite frankly, I just don't have it, because I'm sure you're not feeling very happy about the fact I'm asking to have you removed. I guess I pretty much said what I needed to say, and we can continue if you want to, but should I put in a motion? I gave you the first motion. Shall I read in the second and third? Is that necessary for you? Okay, we understand what we're talking about. I believe there is a complete distortion of what the Supreme Court says and the actions that is being taken by this body. We are correct in what I'm saying? I heard you. Okay. Thank you. I believe I'm okay for right now until you make your decision, and then we'll go from there. Thank you.
122, Kanaile. Mr. Kanaile.
Yes, this is the motion part in Mr. Vicente's jurisdiction of.
It's your document 122. It's a motion to join,
Oh,
122.
okay, motion to join. I got that right here.
And I assume you're not moving to join, you're just joining, right?
Yeah,
So I'm not going to rule on the motion, but I'll allow you to join the motion.
okay.
Go ahead.
Good. Just like to just say the poison tree doctrine, that once you have broken the law, from then on you can make all the laws after that to justify the first breaking of the law, which is the state of Hawaii, territory of Hawaii, the whole thing we're going through right now. So I just want to make that point, that this is all part of the poison tree doctrine of occupation, illegal occupation of the civil and military of the United States of America and its political subdivisions, and that we agree that Dwight Vicente is correct as far as his assertions of sovereignty for the Hawaiian, and we're still here. If you look in our first part of being part of this contested case hearing, you notice that the only Hawaiian institution from the Hawaiian Kingdom was involved, called the Royal Order of Kamehameha. Royal Order of Kamehameha, they were involved back then. So we know the Hawaiian Kingdom is still alive, and we're still here. We never die. We've been forced by civil and civilian occupation, military occupation, to suffer these injustices against us here. Oh, and one more thing, an identity theft. We just, the new general public of the Hawaiian Kingdom, we have that. There's no state of Hawaii general public. There's only trustees, self-appointed trustees. They got together and voted some thing called a state of Hawaii. Public law 414, collective naturalization without consent is not correct. So whatever definitions of what a Hawaiian is a race, is not a race, it's a nationality. Kanaka is the race, and the true beneficiaries is the king, the chiefs, and the native tenant, and that's who we represent. Everybody else is part of the new state of Hawaii, or the new whatever that this is. That's all I have to say.
Mr. DeLeon, document number 123.
Aloha kako, Judge. But I have nothing more to add on to his motions, but I fully support his conclusions. Thank you.
While I appreciate Mr. Fergerstrom's efforts to clearly separate the issues and articulate that there are three separate issues, it would be helpful, and you'll see why, if each issue has its own motion, and then it will show up as a separate motion in the documents library. The reason I say that is, as I said to Ms. Kihoy, until you are a party, it's true that you did not have the opportunity to file motions or participate like the other parties. But since you were a party, made a party on June 17th, you did have the opportunity, and you exercised that opportunity by the filing of this motion in a timely fashion. And by the filing of this motion, you are challenging the decisions that I made prior to your entry as a party, which is your right to do. You also have moved to strike the motions, applications, decisions, and move to make moot the entire hearing. On those issues, I'm denying the motions. I find that they are baseless, and that I really don't have any legal basis to grant these motions. I hear what you're saying about, it's your interpretation that somehow the Supreme Court's remand causes you to believe that where we pick up in this proceeding is we're not in the right place. We've dealt with that issue. You certainly have argued it again here. I've made the decision that that's not correct, and that I've therefore denied parts of your motion. The third motion to remove me, the Attorney General, and frankly, I don't take it personally. That's part of the job. It's part of the process, so no problem. But I don't make the decision on the disqualification of myself. Somebody else has got to look at that. So I have to refer that matter to the BLNR. As I've indicated, all challenges to my sitting as a hearing officer have been decided by them. The other challenges that you have as to the Attorney General Julie China and DCCL person Michael Kane, I'm going to defer hearing on those issues till next Friday, when others are going to be addressing the same arguments, and give you, Mr. Fergerstrom, an opportunity to speak at that time on these particular points. But we're going to stay focused on that.